A major Second Amendment case is heating up in the federal court right now, and depending on what happens next, it could answer a question the federal government apparently settled decades ago without expecting anyone to ask follow-up questions. Now, back in 1998, Patrick Atkinson pleaded guilty to 1 count of mail fraud. Just one. That's it. Not murder, not armed robbery, not leading a pirate fleet through the Gulf of Mexico, or America, whatever we're going to call it now. Mail fraud. That's it. And he wasn't even sent to prison. No, he got probation. That's it. And he completed probation. And according to court records, he spent decades staying out of trouble. But federal law says, that's nice. Because under the current system, apparently a mistake made in the Clinton administration is enough to keep affecting your rights indefinitely. Because nothing says temporary punishment like forever. Now, under federal law, Atkinson is permanently prohibited from possessing firearms or ammunition. Lifetime prohibition. No expiration, no automatic restoration, not even a review process. Then came Bruen. And Bruen basically told lower courts, you don't get to just make this up as you go anymore. So the Supreme Court said judges need to look at text, history, and tradition. Yeah. 3. Which means federal judges now spend a surprising amount of time reading documents written by people who thought indoor plumbing was cutting-edge technology. The NRA and FPC argue that historically, America disarmed dangerous people, not necessarily every person with a nonviolent conviction. Their brief goes through colonial laws, founding era practices, 19th century legal traditions, basically enough historical research to accidentally earn you a college credit. Ugh. If history supported disarming dangerous individuals, where exactly is the tradition of permanently disarming a peaceful person because of decades-old nonviolent offense? This case could eventually head toward the Supreme Court. And if you followed Second Amendment litigation lately, you know the Supreme Court has been receiving gun cases the way my inbox receives spam emails. Really, it's pitiful. So the question is whether they'll decide this one is important enough to actually take. Now, supporters say a person who completed their sentence decades ago shouldn't necessarily lose constitutional rights forever. Opponents say felony convictions are serious and permanent firearm restrictions protect public safety, which means both sides think that they're defending the Constitution, and both sides think the other side is completely wrong. So basically, it's just a normal day in American politics. So whatever happens next, this case could help define who can permanently be disarmed under the Second Amendment. And after Bruen, courts can't simply just say, yeah, this sounds reasonable. No, they have to prove the restriction fits America's historical tradition, which is why modern constitutional litigation increasingly resembles an extremely expensive history project. If you are sick and tired of all these politicians telling you that they care about you, that they want what's best for you, but they're trying to restrict your ability to defend yourself, trying to take away your Second Amendment, trying to pick and choose what you can and cannot own, go ahead and hit that like button for me. And if you want to follow along with a case just like this to see what happens next, go ahead and hit that subscribe button. I would greatly appreciate it. Until next time, we'll see you later.